that up.
Huh?
No, or you can leave that up, or you can leave that.
No. I need to get the marker. Okay. So, if the district court decides to hear the writ, then they will remand the petitioner back to court.
Right.
Okay? Now, if they reject it, what you see at the heading of this, where it says the Court of Criminal Appeals, by operation of law, which means automatic, this writ will go to the Court of Criminal Appeals.
Okay.
Okay? But district court, the convicting court, has an option to settle it in their courtroom and not send it to the Court of Appeals. Okay? Not that the Court of Appeals would overturn the case or remand it back to court anyway, because 9 times out of 10, more like 10 out of 10, they agree with the convicting court. And they would, because they would lose a conviction. Okay? Nobody likes to admit that they were wrong. Okay?
Exactly.
And it makes you look bad if the person went through a lot, you know, when you convicted him, or his family, or some tragedy or something. Okay? It all kind of falls back on the state, because it makes you look bad if you convicted the wrong person. Okay? Or, you know, you did something unconstitutional to violate that person's right. Okay? So they never want to give it up. Okay? So, now we go to the circumstances, you know, which surround the case. All the information. In the writs, they will ask you, you know, actually they're asking the inmate, okay? Because the majority of the time, whether the attorney files it or not, the state still requires for an attorney to use this form. That's why at the bottom of it, it says either pro se, you know, or, you know, name of the attorney. Okay. So when we do it, we sign Texas Writ Writers Association, and then we bring in the attorneys when we get to that, you know, level that it needs to be argued. Okay. All right. Then there's the you're going to go through the whole thing, you know, up into, it asks you all these questions about, and you will know this, if you go into the file, you will know, or you should know, or there should be the information in the file that tells you whether he filed a direct appeal, or whether he did file a writ habeas corpus, or somebody filed it for him. Whatever the circumstances are, that information you will find in the file to answer those questions. If for some reason that information is not available to you, then you will either put no file, and if there is a file, there should be an address or a phone number attached to that file where you can contact that person by mail, or if you can contact them by phone, contact them by phone and say, hey, we're missing something, or what's your birthday, or what's your address, or whatever. You need.
Would it only be the person that's on here, or if we have another name that you can call?
If you have a contact number, you know, they might be able to help you.
Because it might be the mother
Yeah,
or the
could
father,
be,
or whatever.
yeah.
Because I've seen a lot of cases like that.
You can do that. They'll
Okay.
give you that information if you don't have it.
But we're only getting that information on people that have already filed, correct? I
No.
mean, we're getting it on everybody that sends us information?
Well, we have files in there where no one has filed a writ of habeas corpus, nobody filed an appeal, nobody
Right.
did anything,
Yeah, right.
okay? And they're just sitting there and untouched. So we have to look at them to see, you know, what's wrong with them, if anything, okay? Not every case that you read has a remedy. There are some people that are guilty I had I mean, really.
I know.
I had a case the other day, I don't know if you read that letter, where the guy's telling me that he did murder his girlfriend, okay? They got into a fight, and he hit her and she fell and killed her. He's telling me that even though he killed her, okay, he should not be charged with murder. He should have gotten a second-degree manslaughter or maybe even a probation. Okay. Well, you're preaching to the wrong choir. Okay, because I'm not going to go for that. You know, I'm not going to help somebody that's guilty of murder. Okay. I don't care. You know what we do. We're not doing that. Okay. So if we know that these people are guilty, you just basically send them a letter, you know, thanking them for contacting us. But basically, there's nothing we can do for them.
If they flat out admit it? just-
Yeah, like that letter.
Yeah.
I mean, that guy just flat out admitted it.
Uh-huh.
You know.
Is the best way when you do write, well, I know Tracy's the one that does it, but I mean, is the best way to address it is at this present time, we're not able to
Yeah.
help you or assist you in any
Right.
way, form, or fashion?
Yeah.
It's just kind of where it doesn't
Right.
sound like, hey, we can't help you, and that's
Yes,
it.
ma'am.
Like, I just read, it was a mother and son deal, and like, we had nothing, it was just a letter that she sent in and stuff. But it was like her ex-boyfriend her boyfriend killed her ex-husband, stuff like that, and she was a slave. Anyway, so those kind of cases, even though we don't have any information, just send us a letter. We're gonna go in and look into that.
Yes, and I'll
Okay.
tell you why.
The son is
Because
saying
let
that
me
you-
tell you, we have a file in there that's this thick, and there are no court documents in it whatsoever. It is, however, very neatly typed into different categories of events. The entire file is a file of the boy's mother explaining to us what happened, you know, from her, you know, point of view. And we can't go by that. You know, if you told me, you know, my wife killed this person or didn't kill this person because, and the evidence shows, well, show me the evidence, show me the documents. I want to see something official, okay?
Right,
because we can't go by somebody's word. Everybody's going to give you a sob story. That doesn't mean that they're telling the truth or that they even know. Because this lady, you know, could be questioned on the fact that, well, maybe you had something to do with the crime because you're so detailed in explaining what your son did and didn't do. Were you there?
I know, I thought the same thing.
You know, I mean, were you there? Well, it looks like you were because you are definitely. And how do you know this? Your son shares this kind of stuff with you?
Yeah, right, huh?
You know, he's charged with child pornography or something, and you know all this about his case. Why? How do you know this? See, so we can't go by that. You got to go by documents, court documents, okay? Nothing is factual without
Right.
court documents, okay? Unless we find something that is factual, that is not in the record, then it becomes new evidence, okay? And that alone could get us a new trial, okay? So you got to watch for that stuff. Now, then you get down to the part where you get to ground of error number one, okay?
You get what?
It'll ask you the grounds of error.
I don't think so.
You guys don't have a full set. A full set has all that. You can follow me with a full set.
Okay.
You can get lost on page one.
Okay, but like, say that one I was talking about,
You
since
have
we
a
don't have
full
it, will we write her and say that we need,
Yes.
okay,
If you don't have any documents,
Right, no.
you might want to contact her and tell her, we don't have any
Okay.
documents, and we got to your file, and there was nothing there. Now, you have a certain amount of time to get these documents to us, or your case goes back into the file until we can get to it again. Okay. Be sure to specify that, because, you know, we can't just sit around holding a file. We've got too many to go over, you know, just to sit around waiting for a response. So make it an urgency.
Okay.
I have a pool.
Because we are not gonna go in and do research and get this stuff. They're gonna have to do it.
Yes, we can't,
We don't have, yeah.
we don't have the time or the resources to do that.
I'll just
Okay.
sit over here and look
Okay.
over.
Okay.
Whoa, you're showing.
Anyway, so,
I don't have page 2.
are y'all gonna copy from each other?
Yeah, because I don't have a
Oh,
plain one.
okay, I understand, all right.
One of my own.
Anyway, so then we get to ground of error, okay? If it is a plea bargain, then we pretty much know what to do with that. There's only 3 grounds of error and and we lift the ADEPA law. The ADEPA law is the Anti-Terrorist Effective Death Penalty Act. It was signed into Congress by Bill Clinton in 1996. He tried to do away with the writ of habeas corpus, but the Supreme Court told him, well, they can't do that, but we'll put a year time limit on it. So, as a result, this is what we have. We have the ADEPA law, which bars most of these prisoners from filing anything because they either didn't file on time, or it's too late. They've been in there 10, 15, 20 years. Why in the world would you need to file a writ? Okay? Well, because that man's constitutional rights may have been violated for that entire 20 years, and he's been wrongly imprisoned for the last 20 years. That's why. Okay? We're going to dig until we find the truth. And if we find that the man's guilty, then we close the file. If we find any discrepancy with his guilt, we will dig until we find what went wrong. And then we'll decide what to do about the case then. That's when you get down there to the grounds of error. The first one, always, foremost, before you do anything, is ineffective assistance of counsel. Why would you open up with ineffective assistance of counsel? Why does that have to be the first argument? Anybody know? Because if you open up your writ with ineffective assistance of counsel, then every other argument, ground of error that you put in there automatically goes back to the ineffectiveness of counsel during trial, during the appeal, doing whatever. Okay? Our job is to expose the errors that were committed in this case that are so grave that the man has been incarcerated illegally for umpteen years, okay, whatever, it'd be 6 months. But that's where you're going with the first ground of error. The second ground of error, in a plea bargain in the state of Texas and almost in every other state in the United States, we attack the plea bargaining statute. Why? Because the states created the plea bargaining statute in 1964. They did it because the civil rights movements and the Supreme Court mandated that people of color be given an attorney and a fair public trial. Before then, you show up in court and whatever the judge said, that was pretty much it. Okay. So now people of color have to be given an attorney, but that's going to cost the county and the state a lot of money and a lot of time. So to get through these ignorant people's cases, they made a sweet deal called the plea bargaining statute, where they could just come in and say, Billy Bob, the judge said because this is your first offense, he's going to put you on probation and give you a $1,000 fine, sign right here so you can go home. And boom, there you go. And now, every prison and every jail in this country are full of people who pled guilty and had to plead guilty the second time, third time, fourth time, till they finally got themselves a home inside the prison, okay?